Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Good afternoon. Okay, just going to share something with you that's come up with us today. What is the idea of amending one's onset date during a hearing or even before a hearing? We do this sometimes. What we usually do is if we are at hearing, and it is the kind of case where amending the onset date has some really strong foundational reasons why you would. And when I say amending, that means you're going to move it from, you said you were disabled 3 years ago. Maybe you're going to amend that to 2.5 years ago or 2 years ago, or whatever the case may be for some particular reason. The two major reasons tend to be, that may be valid, I think, is one, you're having an age change situation where you went from, say, under 50 to 50 on a particular day. In that case, a different set of rules applies to you at the 50 date, where you don't have to prove all the things you have to prove at the 49 age. And if you have been lacking the proof of the things you need at the 49 age, but you think you have them at 50, it might be a reason to amend your onset date to 50 if you think it's a really strong basis on which to prevail at that, because you are giving up the opportunity to say that you were disabled at 49 or 48, and you give up the possibly remote chance, but still a chance that you could be granted back to that time period, which means you lose out those back benefits. Okay, so you need to consider a lot of things when you do that then. Would you be getting back benefits back to then, should you prevail in that remote situation? Or would you still not be getting all the back benefits anyway, because maybe you filed 2 or 3 years after your alleged onset date? And as you know, back benefits don't go back that far. They don't go back for SSD further than 12 months of benefits that existed as a disabled person found by the SSA before the date of application. Okay, so things to think about when you're going to amend your onset date. If you weren't going to get all the back benefits back again anyway, that might be something that might compel you to feel more comfortable doing it, aside from the fact that you may have a much stronger chance of winning and getting a fully favorable versus a flat out denial or a partially favorable. The other thing would be, if not the age change, but when you look through your medical evidence, even though you know when you had to leave your job and why and how you were feeling and all that, but sometimes people leave their job and they don't actually get doctor's appointments for another 6 months, or the diagnostics are delayed due to insurance or scheduling, and there's no objective proof of the severity until many months later. Sometimes people will amend them. Sometimes we get a suggestion by the ALJ at hearing, counselor, have you discussed with your client the possibility of amending the onset, because I'm really not seeing a diagnostic until so-and-so date. So what I tend to say on the record is, well, Judge, are you saying that if the client does want to amend onset date, that you would be finding an onset date as of, 8 months later or whatever date they're talking about? And if so, Judge, can I have, 3 minutes off record to, converse privately with my client, and I will just go over this with him or her. And that sometimes is I like to get that on the record because I don't want to amend at the behest of a judge who won't put it on the record that they're suggesting we amend. I don't want to be played. But anyway, amending your onset date, if there is a reason, sometimes It's not that uncommon. Age change and or you just didn't have any records until 8 months later. Trying to think if there's any other bases. There might be, but those are the two big ones. If you're considering maybe, you know, someone who's helping you has said, yeah, maybe you should amend your onset date, or maybe the judge suggests it. Things to consider. You need to know your own medical file, though. You need to know, well, when does my really strong objective evidence kick in? You know, if you're self-representing, if it were me, I would be chronologizing all of my evidence in a document. It could be, you know, Dr. Jones from current going back, all the diagnostic tests, current going back. And so you know when the evidence starts to get robust enough, or you can suspect when it might be, to objectively show, A, that the diagnosis and the diagnosis that would really support severe limitations that prevent you from doing all jobs, or the ones that under the law you have to prove you can't do. And again, that might have to do with your age. So anyway, other things to think about, guys. Amending onset date. It's often a good idea. Not always. Not very often. It's not even implicated, but it is certainly something that comes up. I don't know, maybe 20%, 25%, something like that, at least worthy of consideration. And one may or may not end up doing it. So, all right, I will talk to you later. Have a good one.
Bye.
Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Good morning. This is a little explanation of the meaning of alleged onset date and how it is different from something called the established onset date. When you apply for Social Security Disability or SSI, you, with or without someone else's help, have to have an alleged onset date. This is where you're saying you believe you became legally disabled under Social Security rules. This is kind of a term of art. It generally does not occur at any time before you stop working SGA, which is a different video, if you don't know what that is. It can occur if you're working part-time or you're working under SGA regardless. But oftentimes it's after a person stops working, at least for a little while. And a lot of times people assume, well, if they find me disabled, I get disability from the time I said I was disabled. Not really true. They have to determine what your established onset is of disability. And from a medical point of view, that means they have to find that your medical evidence is very clear that you were disabled and unable to perform any of the jobs that exist in the national or regional economy occupations, of which I believe there are like 12,000, and you could do none of them on a full-time basis. It doesn't have to be just your old profession or job. It will include minimum wage unskilled jobs as well. So your medical evidence has to be that strong and be derived from that time period. So if you allege and in reality could not work, say January 1st, 2022, but you didn't actually start going to the doctor until, like, religiously about it until maybe right after, maybe you were hurt. They may or may not find that there was enough evidence as of January 1st, 2022 to find you disabled because you really didn't have any. They will look at when the evidence shows that you would have been unable to work for at least 12 months. That can be a reading between the lines thing. But so oftentimes on initial or reconsideration, if you prevail, sometimes it will not be the date you wanted it to be. You can appeal that, although there are risks to appealing because you're not just appealing that. You are opening up your case for another review and consideration. So we always go through that very carefully. If one is going to appeal an onset date, you really want to make sure you have some strong evidence to pinpoint why it would be earlier, something major prior thereto. I have seen cases where I can't figure out why they picked a later onset date to establish as being the official date. So sometimes it's worth considering appeal, but always the risks have to be discussed and taken into consideration, the cost of the risks. The established onset date will be the deciding factor in the end, assuming you don't appeal it and prevail. And again, that does not necessarily mean you're going to get paid from that time forward either. And this is because there's two things. There's a 5-month waiting period. So the month that you claim to be disabled and are established to be disabled, I should actually say it's the established date. 5 full months later, the following 5 months are not payable. And the 6th month could be your first payable month, whether that's prospective because it hasn't occurred yet, or it's in the back window and it's going to be back benefits. Another impediment, and this applies to people who delayed too long before filing, they're never going to pay you more than 12 months of payments before your application date. So if you were, you file in January of 2022 and you say you were disabled in January of 2020, if they agree that you are disabled in January of 2020, they're not going to pay you benefits from January of 2020, nor from June, July of 2020 after the 5-month waiting period, because they're never going to pay you more than 12 months before the date you applied in January 2022. So generally, in that instance, you'd be paid from approximately January of 2021 to January of 2022, plus any months that have passed since you applied. That's another reason, and it's a different video, why you should consider getting a protective filing date the moment you know you're going to file for disability. You have to do a lot of paperwork and get a lot of information before you can actually submit the application. So you can get a protective filing date that can last for Social Security disability 6 months. If it's an SSI claim, it would only last about 2 months, 60 days, I think. And with regard to the waiting period that I mentioned for Social Security disability, that does not apply to SSI welfare. So if you're applying for that, there is no waiting period. You're going to get paid from the moment they find you disabled after the date you applied. There will not be any retro though with SSI. So again, you want to get the protective filing date almost invariably for SSI. It's only going to last you 60 days. That's enough to get your paperwork in. So if you get your paperwork in October, but you had sent in a letter saying, I'm going to apply for SSI in August, they're going to give you the August date as your date of application. And if you prevail on your medical evidence to show that you were disabled in August, when you have that protective filing, you'll get paid back from August. You won't have to start your payments in October. So all things to think about, but those alleged onset dates and established onset dates are different. An alleged onset date, though, is really important. I wouldn't hesitate to go deeper back in time if you think you were disabled and could possibly have met the financial and insurance requirements at that time, financial in terms of working income. When in doubt, generally, I think take your deepest, oldest date. They're not going to give it to you if it doesn't apply. So no harm, no foul. But if you don't ask for it, they're probably not going to give it to you, and it could have been valid. So you have to ask for it if you think it's remotely possible. You can always amend it later. Sometimes that happens when we go to hearing, when we have all the evidence and we realize that date isn't going to fly for a number of reasons. We can do everyone a favor and amend the alleged onset date to something that the judge could actually potentially award on. So consider all those things. If you have any questions on any of these issues, you know how to reach me. Good luck with your claim if you're filing, and have a great week. Bye.